Please. Lordship, I would like to mention item number 9. Your Lordship, in this matter, I have filed my affidavit this morning.
Yes,
I have also informed the same to my learned friend, Your Lordship.
yes. You received the copy?
Yet to receive, Lordship.
Yet to receive, okay.
I
Rece-
have- yes.
Receive now.
Yes, I have submitted now.
The government advocate submits item number 9,
Yes,
submits that the affidavit in opposition has been filed today. And a copy thereof has been served on the counsel for the petitioner. Stop. Matter be listed.
Lordship, kindly give me a short date because there's an urgency in hearing this case.
You tell me,
So Lordship, next week, if it can be fixed, Lordship.
right, be listed on Thursday next. Which will be 14th. 14th.
Lordship.
14th, as requested by learned counsel for the petitioner. Registry to ensure that the affidavit filed today in court is connected to the case record. List accordingly.
Lordship, I also like to mention item number 10, Lordship. In this matter, Your Lordship, I'm yet to file my counter affidavit. If 3 weeks time can kindly be granted, Your Lordship. I've informed the other side.
Any objections? Right, matter stands deferred to be listed after 3 weeks at the request of learned government advocate. Enabling him to file the counter affidavit. Counsel, prayer made is not objected to by the counsel for the petitioner. List accordingly.
I'm deeply obliged.
I think the mention item number 6.
Yes.
On behalf of attorney. Please say the receipt instructions, so kindly grant trading time.
Who's for the petitioner?
So I am for the petitioner, Lordship, they have been taking instruction time and again, and this is a matter of compassionate appointment. So if
Your case has not been considered.
not been considered, paperwork of process, Lordship, and all the words of consideration, Lordship, they have stopped everything.
Yeah. Thursday. Next Thursday.
I will put that, please say the receipt instruction.
Ask him to obtain instructions. if possible, by Thursday. It's a case of compassionate appointment. They're only required to consider his appointment
Yes, Lord.
But if, 1 week, Lord Chief.
1 week. So we'll keep it on Thursday, let us
Yes,
see.
yes.
If you are in difficulty, we'll see how we can accommodate you.
Okay.
I'm obliged.
Item 6 at the request of learned government advocate, matter be listed again on Thursday. The government advocate is permitted to obtain complete her instructions in the matter. Mr. Senti Yanga appears for the petitioner. Yes,
Item was 7. On behalf of
Lord Chief, I have no objection.
item 7 at the request of learned counsel for the state matter stands deferred to be listed after 3 weeks. You want to file affidavits, enabling them to file an affidavit. Stop. Prayer made is not objected to by the counsel for the petitioner. Yes,
Lord Chief, similar prayer with item number 8.
I have no objection, sir.
same order in item number 8 also.
Obliged.
Lord Chief, I also like to congratulate every item number 1. On behalf of the
After 2 weeks, right. Item 11 to be listed after 2 weeks at the prayer made by the state council. Prayer made is not objected to by the council for the petitioners.
Lord Chief, has been changed.
Interim order passed earlier will continue.
Lord Chief. So, Lord Chief, which I like to mention, item number, supplementary item number 15 and 16.
Yes,
Lord Chief, this is particular matter and it was passed over yesterday. However, the letter CTC, Mr. Yamarwati, is in the different day. So, first step maybe next week.
when can we give you a date? Court master,
Thursday.
court master? Tuesday?
Tuesday already 7 items.
Tuesday, I have 1 meter fix. Two.
Thursday, 4 items fixed. Just
How about Monday?
Monday,
My learner
many fixed.
friend here, difficult
Alright,
because
alright.
treatment is more.
Oh, but will you be available to come back on Thursday?
Thursday, yes.
All right, Thursday. That would be 14th. List on 14th, as it is submitted. On behalf of the learned CGC that is in bereavement. Stop. Prayer is not objected to by the council for the petitioner. Stop as agreed to by both councils, matter be listed on 14th, Thursday.
March.
Yes.
For motion, item number 1.
Yes, not good. And this one was issued by the Netherlands Council on 15th of December last year. And there were several posts which was introduced among those ones. One item number 4, 61 posts of they fixed up with logic.
No, you're seeking impleadment by this IA.
Yes, logic.
Any objections? No. We'll have to pass an order for impleadment. Only then you come into the picture. We are asking who's the use for that government? Any objection?
No. And the reading is stated not in the 283. That is, secretary. I can bring stuff looking for, I will develop definitions.
You represent chief secretary, controller, commissioner and health is, and who's for health? You're representing health. Are you representing health also?
Yes, yes.
You're instructed by the petitioner council? No.
No.
Okay.
Because.
Heard.
I have no objection.
No objection. You are not yet a party. You are not yet a party. Heard, the counsel for the petitioner, for the applicant. It is submitted that this IA has been filed seeking impleadment of the opposite parties. You want to be impleaded as respondents.
I
Then?
want to include private respondents.
Where are the private respondents?
Private respondents also, I mentioned in that prayer. 67 afterwards.
No, you have to mention it here also. In the
chart also, what's in my petition as well.
in the course title. So you are mentioning it from page 19.
Page 2, yes, as well as page 12, also. Page 12, I have given the table,
Okay. From serial number 1 to
67.
67.
Yes, Lordship.
You are for the writ petitioner.
Yes, I am following.
And what are you challenging there?
Lordship, I am challenging the origin of Lordship. Because Lordship, it so happened that the policeman was issued, criteria was qualification was left out. And then testing of the selection was conducted. And result was declared on 22nd of June this year, Lordship, May, Lordship. Now, immediately, the very next day, Lordship, another corrigendum was issued by which, by our selection, it was cancelled, and by tinkering with the qualification, they added another qualification, and then the private respondents, Lordship, they were selected instead of
Alright.
me, Lordship.
This IA has been filed seeking
Yes.
impleadment of the appointed candidates
Yes, my lord.
who were appointed by the state respondents,
Not appointed, Lordship, selected. Yes.
selected candidates who were selected by the state respondents during the selection process for filling up the posts pursuant to the advertisement at page 28.
Yes, Lordship.
Pursuant to
Page
the
28, Lordship.
advertisement dated 15/12/2023. Stop. It is submitted that the present applicants had also applied for and were shown to be selected initially. However, subsequently, their selection was cancelled and the candidates whose names are sought to be impleaded as party respondents are shown to be selected. Stop. The writ petition has been filed, putting to challenge the said selection, and accordingly, the learned counsel submits that the candidates who were selected in place of the applicants would be necessary parties, and therefore this IA has been filed seeking their impleadment as party respondents in WPC number 122 of 2024. So there are learned senior government advocate appearing for the state respondents does not object to the prayer made. He represents all the respondents, all the sorry. There is one association. Anyone representing the association?
No, Lordship. You are not representing the association.
No, any council? Are they are parties in the writ petition?
Yes, they are participating.
Who is representing them?
None, they are not.
They are not represented.
We have not appointed any council to the best of my knowledge.
All right. Represents Mr. Senior Government Advocate, State of Nagaland, appears for respondents 1, 2, 3, 5, and 6. Stop. None represents respondent number 4. Stop considering that this is an application for impleadment of the candidates who were selected in place of the applicants / the petitioners. They are necessary parties and are required to be added as party respondents in terms of the prayers made in the IA. So the order for impleadment can be passed in the absence of counsel representing respondent 4, as respondent number 4 is also represented in the writ petition and will get his opportunity to object to the prayers made by the petitioner in the writ petition. So considering the submissions made, this IA stands allowed. The persons named from serial number 1 to serial number 67, whose names are shown in the in para 3 of the IA, as well as in the prayer portion of the IA, are added as party respondents after respondents 1, 2, 3, 4, and 5 in WPC number 122 of 2024. IA accordingly stands disposed of, allowed and disposed of. The petitioner, the applicant will file amended course title in the registry along with a copy of this order, and the registry thereafter will make necessary changes as required in the court records of WPC 122 of 2024.
So, my lord, the small concern. There were 68 candidates who were selected in my place also. Now, we have discovered the name and particulars of 67 persons also who were included. The 68 person also, 1 person also, who is bearing roll number 3000810. His names are in particulars also, we are unable to find out in now also. So if we include the 67 private respondents, but we need to be implemented in representative capacity so far as the 68.
That you mentioned in the writ petition.
My lord,
When the writ petition comes up, today we are passing an order in the IA
this first,
allowing your prayer seeking impleadment.
this first.
So there will have to be some changes made in the writ petition. You file the amended course title within 1 week. Did we say 1 week? Shall be filed within 1 week from today. Then in the writ petition, you say, in view of orders passed in I 179 of 2024, you have to give the names available here from the chart, paragraph 3. Paragraph 3 of the IA, the entire chart. The names mentioned in the chart are added as respondents from 6 onwards in WPC 122. There will be 67 and 5 respondents. How many respondents are there?
6 already.
6 already. So you add the numbers. So from 7 to so and so, they're added as respondents, right? Then you take, you are appearing for these respondents. Mr. I. Jamil, learned counsel, has entered appearance to submit that he has instructions to represent the newly impleaded respondents. So his presence is recorded. His presence on behalf of newly impleaded respondents from 7 to so and so are recorded. He is permitted to file his objections / reply affidavit in opposition within 4 weeks. Right. State has filed. State of Nagaland is also permitted to file their affidavit within 4 weeks. Matter be listed thereafter. Is there any interim?
No, what's this?
There's an interim order. Right, then you make it 3 weeks, list after 3 weeks. Let the matter be listed again on 2nd of December.
Since you newly did what's the power? I think I just took the copies.
That's what we recorded. We recorded. So therefore, you just add one line, Mr. Ijami's name is recorded. Court has recorded his presence. Since he represents the newly impleaded respondents, notices are waived, extra copies be furnished within a period of 1 week from today. A matter be listed on 2nd of December, interim order passed earlier, will continue until the next date fixed.
Much obliged.
For admission, item number 2.
Yeah, please, motion. My lord, as granted by the honorable court, I filed the state has filed their compliance of the implement.
Yes.
Also, mechanically, the
Yes.
it was filed on 22 October. There,
Yes.
para two. That by the honorable court order dated 37/2024 directed the state respondent to submit status report of the letter dated 14/4/2023 by way of negativity. Accordingly, in compliance, the deponent completes to state that upon submission of letter dated 14/4/2023 by the respondent of court has been taken into consideration. Since the matter relates to the creation of 9 supernumerary posts of web technician, it has been under submission to PNR government for examination to accomodate 9 web technicians who have served more than 15 years without promotion. Part 3, that is mentioned here that since the matter is in regard to the creation of those, for which a lengthy process and formalities have to be followed for consideration. Therefore, it is complete appeal and submits that some more time will be granted to the state respondent for completion of the process. So, my lord, since the matter is related to the creations of 9 supernumerary posts, it takes time. So, my humble submission.
What time? Who says it takes time?
No, because.
It's a question of passing an order, that's all.
Because, for creation of posts, it has to. be.
Supernumerary.
Yes,
These are not regular posts that you are creating to accommodate people. They're already working.
yes,
There are no posts. They were drawing a salary.
yes.
So you have to just create a supernumerary post so that they don't go without their service benefits.
Yes.
So it doesn't take much time. You're not these posts will go away with their superannuation. Once they retire, the posts also go.
Yes. So, my lord, since the matter is under process.
You expedite the matter. We'll give you 4 weeks time. 4 weeks.
My lord, if your lordship agree, let the matter be disposed of with the direction to the respondent to consider as per the letter, the placing of this affidavit.
Yes.
Next, the lordship, specific time will be given for the direction to complete the process.
Yes, my lord.
Where is that order which you are required to comply with?
Well, there is no specific order,
No, the order of 12/9, 12/9. Where is 12/9 order? Twelve-9, yes. Where is the letter dated 20-207? 27? Where is the letter?
In the technical capital development. By the.
Yes.
There is a date.
Yes. If you look into the last order of 12-9, do you have a copy of that order? You have a copy of that order?
Yes, yes.
Please come to the last paragraph of the first page. Do you have a copy, Mr. Counsel? You got it?
Now the code is.
Digital copies are not always helpful. They rely on some paperwork also. Yes. Have you got it?
Yes.
You have the copy? Do you have the copy of the order?
Yes.
You show it to him, please. Just go through that order which is given. Last line of that first page. Learned government advocate. Have you got it?
Yes.
Please read it.
Shall come on the next day. On the next day, come with proper instruction as to what action the government has taken on the letter dated 27/2023, submitted by the office of the Director General of Police for creation of national post of the brotherhood condition in the police department. The instructions shall be in the form 150.
Yes, then see the next line, next paragraph.
It is made clear that if no instruction is placed before this court, as directed, the case shall be heard on the basis of the material available on the courts.
So the direction of the court is to come up with specific instructions. And look at what have you stated in para 2 and para 3. There are no specific instructions.
So my lord, here it says in the last paragraph,
Hmm.
it has been, some,
Under
under
submission.
commission to ANR department.
So
Where is the latest,
where is that communication? That it has been forwarded or sent? No, this is the communication to you. Where is that letter by which it has been sent? Have they not sent you?
no, only the letter.
No, they'll have to send the papers, but how they have sent, who has sent? What is the recommendation of which department has sent it?
Home department.
Home department. So what is the recommendation they have issued in that letter?
That copy of the.
You have to show it. You have to satisfy yourself first. See, you are an officer of the court. Forget about your clients. Your statement, we rely. We proceed by relying on your statement. So when you make a statement, you must satisfy yourself. They have given you a letter, they have not given you any documents. So you call for these documents and you satisfy yourself that papers have gone and what is stated. And then you tell us, because this is the direction of the court. Court's direction has to be complied with.
Then my lord, let the matter be called next week.
Yes.
Some question. Documents.
What is your prayer otherwise in the writ petition?
To go by the order, but by the direction general to
The order passed in the, enclosed in the additional affidavit. Which,
no, you're watching. This is the second round of litigation. In the first case, a direction was given to the state respondent to consider our representation. What happened was, in the writ petition, page 47,
yes,
the decision was taken to promote us to NAC. Since there are no post of lab technicians. Now this, after
Your-
this came out,
you're serving as lab technicians.
we were appointed as lab technicians, but then since there are no posts of lab technicians, we were accommodated against constable general duty.
Okay.
No, but in the case of others who were appointed, they were given lab technicians, they were appointed as lab technicians. The scale of pay is also different. Now what happened, we submitted representation, that our case also could be considered. Like the others who were appointed as lab technicians. Then our representation was not considered, so we approached this honorable court. This honorable court, by their order, we just stated 2019 in WTC 121,
Hmm.
2019. Directed the respondent to consider our representation. Based on the order, this order was not final, which that we will be given promotion to that. Now what happened? After this order came out, some orders were issued promoting some of us to black, but it was controlled by the department itself. Police, officers in the various districts, they started giving complaints that we are not willing to undergo training. We have given informed our authorities orally because we were asked for it, that if it entails undergoing training, although we are willing. But this order was never applied in our case, because the commanders of the various units, they were unwilling to promote us. So we have approached this honorable court.
So
with a very
promote you as what?
Nine.
Nayak. But the order is already there.
It's already there, but what happened was some orders were issued. I'll give you some, I'll take your.
Say page number 49.
Yes. 49, this was withdrawn.
Where, by which order?
No order, it was. The project will see page 51 order. Very interesting.
So what training are you required to go?
The basic training, police training, basic police training.
As
That's
what?
they are saying.
As what? As constables or nayaks?
As according to their system, we have, all the police personnel have to go basic training. That is the only.
Then
Then we submitted a representation to the page 52.
okay, after that, what happened?
And after that. Nothing happened, okay? We were informed that we cannot be given
Where is your appointment order?
the next year. One, the lordship, then the next one is the selection. And then the next year. Two. Our next year, we do a next year. Nine. Fact copies are provided.
What is the job of a lab technician?
Lab technicians to assist that. Especially with regard to blood testing and all this. Purely medical.
But there are no posts of lab technician.
That is according to the interview was conducted for lab technician, we were selected as lab technicians by the extra mark. But what happened? After our selection, we were accommodated against conservatively, and we are serving as lab technicians in the various hospitals and medical centers in the various facilities. And your lordship, interestingly, if your lordship may come to some examples, okay? Page 29.
But you are essentially a constable general duty.
Yes. Constable general duty. That is the. But we are rendering service as lab technician.
Maybe.
Yes.
Therefore, you're a constable general duty. You
Yes.
can be put anywhere.
Yes.
So are there any rules governing the services of constables or
No, only the police manual is there, and another police manual.
what does it say?
It's a big volume, I have not got it with me, your matter, it's there.
Police manual, is it here? Get it? Now, your basic appointment was that of a constable, in the post of a constable,
Yes.
but you were allowed to work as a lab
Lab technician.
technician. Now, meanwhile, you were promoted as Nayak.
Yes, we are doing, but that promotion was.
You did not attend training. Go and
No,
attend.
we even gave our, what happened was they never gave us any, they never issued any queries as to whether we will be willing to undergo training or not. Your Lordship.
There's no question of,
No, Lord.
no, there's no,
We said we are willing.
no, there's no question of asking you.
Yes,
If you're a member of the police, you have to
Yes.
go for training.
true, Your Lordship. So we also gave our assurance that if we are needed to undergo training, we are going to undergo training. I have made specific
Yes.
statements.
Then you are not put up for training.
No, never. That was a problem. That is a problem. In our representation also. The last. Page figure, what is the representation? 52 and page 53, last paragraph. Paragraph 6. Okay?
Just one.
That is respectfully, I really got to never.
What is piping?
15 ceremony is putting the rack,
Okay.
yes. Pinning the rack.
So, page number 51 of the writ petition.
Yes, page 52, there was page 52,
No, come to 51 first.
yes, page 51.
51
Yes.
is about you.
Yes, it is about me.
So you have refused to go for a training.
That is what they are saying, but we never.
You
This is
never,
why in our representation, we have made it very clear. Page 52. This is the representation which we have given to the authority.
right.
Page 52 and page. The relevant
Hmm,
paragraph is paragraph 6, page 53.
yes.
if I may. That it is respectfully iterated that we may never ask whether we are willing to undergo basic training. And when we have never been asked, we also never informed our authority that we shall not undergo the basic training. In fact, we are willing to abide by any terms and conditions laid down by the department. And if the department in its wisdom deems that despite the lab conditions, we must undergo the basic training. We are ready and willing to undertake this.
Then what happened after that?
After that, nothing happened. This is why we have approached this honorable board by way of this internet.
Hmm.
During the presidency now, they have put up our case for appointment of flat petitions against the Supernumerary.
Okay. What is their affidavit? What have they stated in their affidavit?
For my lord, in the,
There is no affidavit.
no, there is not right.
Oh,
Only in-
Additional affidavit and then compliance affidavit.
additional by whom? By the state. Stating what?
That they have put up our case for creation of nine supernumerary.
Huh?
And it's, there is 27, 23.
proposal that we can, whatever.
And this is for laboratory technicians,
Yes,
not as NIACs.
no, now they have taken a U-turn.
No, now also they want, okay, 9 posts of supernumerary as NIACs.
Not nice,
Then?
not official.
No, what is this letter at, this is of 2nd of August 22. Copy is available here. This is to the additional senior government advocate from the Inspector General, Deputy Inspector General. This is for creation of 9 supernumerary posts of NIAC. So what posts are you creating? Is it NIAC or lab technician?
Only this, that technician.
No, but you see this letter? You see this letter? You look at it. So give it to the government advocate, please. Can you open one window? Just open one window, let some air come in. This is for lab technician. Sorry, NIAC.
Yes.
Then
The last line it says that, nine student was a night to accommodate promotion of lab technicians.
no. So what supernumerary posts are you creating? Is it lab technician or NIAC?
Lab technician.
No, this letter says NIAC. Your compliance affidavit says lab technician.
Yes,
Then what is the position?
it is the lab technician.
But then has this letter been withdrawn? This is the letter sent to the government advocate.
In the next page, it says proposal for creation of 9 lab yes, lab technician. The motion depends.
All right, you get your instructions and tell us at what stage it is. Do it by Tuesday, Thursday, all right. We'll have it on Thursday, on which date you give an exact
Yes.
status of what steps have been taken, how the letters have been sent, what letters have been sent, you produce all copies. Heard the learned counsels for the parties. Pursuant to the orders passed by the court, a compliance affidavit has been filed by the Department of Home. Stop. In the said affidavit, it is stated, in the said, paragraph 2 and 3 of the said affidavit is extracted below, is extracted. So, para. From a perusal of the compliance affidavit, it is not clear as to what stage the directions of the court, at what stage is the at what stage the department has proceeded with the matter for creation of 9 supernumerary posts of lab technicians. Stop. Learned government advocate appearing for the court does not have the required instructions. He prays for a very short date. Accordingly, as agreed to by the counsels for the parties, let the matter be listed again on 14th of November, by which date the learned government advocate will place before the court all particulars and the necessary relevant documents to show the steps taken by the respective department towards creation of 9 supernumerary posts of lab technicians to accommodate the writ petitioner. Let a copy of this order be marked to the office of the learned government advocate for onward communication. List on 14th.
For admission, item number 3.
Give it to the government. The affidavit is filed. Ah. What is your submission?
The senior government advocate has stated that she has further instructions to obtain.
Further instructions. This is for minimum scale of pay. When do you want the matter? Tuesday. All right. At the request of learned government advocates, matter stands referred to be listed again on Tuesday. Counsel for the petitioner does not object to the prayer date. List accordingly on Tuesday. Tuesday is 12th.
For admission, item number 4.
This motion. This instruction.
Affidavit not filed.
Not good.
You want to file an affidavit?
Yes, but is the instruction received that joint spot verification has been convened to be held on 12 November 2024. I have to wait for the.
All right. Learned government advocates has placed before the court a communication issued by the Deputy Commissioner Dimapur that the joint spot verification in connection with the portion of land, joint verification of what? Of the land,
Yes.
of the land, of the concerned land, in connection with the present proceedings is fixed on 12th of November. Stop. He therefore submits that the matter be deferred to be listed after 12th. Counsel for the petitioner as well as for Private respondent does not object to the prayer made. Let the matter be listed after 2 weeks on a date to be fixed by the registry. The government advocate will apprise the court the result of the joint spot verification on the next date fixed. You take back the instructions. You do one thing, you make a copy, keep it here, if they want.
For admission, item number 5.
Please, your lordship. Your lordship, I pray for 3 weeks' time. to finally complete.
Counsel for the petitioner prays for and is granted 3 weeks' time to file affidavit in reply. Counsel for the government advocate appearing for the state does not object to the prayer made, list accordingly after 3 weeks.
For hearing, item number 12.
Yes.
In person for order, dated 4/11/2024. I was instructed to advise the board yesterday and legal vacancy reflected in my communication dated 14/6/2023. And lordship, I will receive the allowed place.
What is the name of the petitioner?
When it clear,
When you pay register.
So what is the position that you want to reflect? Are there vacancies? No. There appears to be one. The handyman. Total number of vacancies, 6. 1, 2, 3, 4, 5, 6. The second last one. That's a vacancy.
These are technical course in the language.
Huh.
This was the one of the days. All the rest. So,
But they have shown the vacancy position. There are no vacancies.
Lordship, as per this letter, Lordship, versus vacancies. And the proposal has been sent to the commissioner to fill up those 6 vacancies. Lordship, this letter shows that we are not in commission. Unless there's a judicial order by this court, my case will not be considered. Really. Therefore, I have to bear Lordship. Plus, a correction may be issued. So, consider my case, in one of the vacancies reflected in this letter, or to decide to read petition and merit.
Who's for the respondent 7? You're appearing? Now. What is the government? There's some letter you pointed out last time. Where is that office memorandum?
Each one.
21, okay. Where is your appointment order? Twenty? 27. What is DLRB? District level recruitment board.
District level recruitment board.
Recruitment board. So, was it considered by the DLRB? Where is the reference to DLRB? Is it there in the office memorandum?
No.
When did your husband die?
2013. That's what everybody is on page.
Can you give us the date?
This page. Seven, nine,
11/9/2013.
page.
And when did the respondent seven's father die?
Year 2017.
Not July.
4 July 2017. Just 1 minute. What is the name of the respondent 7? Zekote. Now, in the affidavit filed by the respondent 7, there is a communication at page 23. Which encloses the seniority list.
Yes.
Why is the name of the petitioner at serial 3 when her husband died at 2013?
This is a misconception of the protocol. This really is was.
Because you submitted late. Date of receipt of application is in 2018.
Yes, Your Lordship. Our application related in the petition.
You did not give your application.
In the year 2018. And in the earlier occasion, I referred to your lordship one application, reminding the authorities to consider my case in the vacant post.
When is the first application filed?
Just after the death of my husband.
Is it available here?
It's not available. However, this number 4, the written response government to furnish an application, which I have that application, which was submitted in the year 2020.
Is it?
It's not part of record, it's not, it was not available with me at the time of time.
So from where do you get a reference of that?
From Roshi. From wording letter. Page 25.
Page 25. Oh, application. This is in 2013.
Yes.
Okay. Yes. So as far as the government is concerned, you are to you are saying that you are following the seniority list. But there is no reason, how have you responded to this particular document at page 25 of the writ petition in your affidavit? No specific denial, no specific denial. Okay. Now, respondent 7, we propose to allow the writ petition with a direction to the government to reconsider, redo the seniority list. Because they have not denied the existence of this letter at page 25 of the writ petition, where it refers to an application made by the petitioner. This forwarding letter itself is in 2013, so which reflects that some application was there, which perhaps was not considered while preparing the seniority list.
Mr. Lordship, and I think I made a prayer to this honorable court to consider this vacancy and see whether the recommendation for regularization made in the vacancies has been made according to the chronological date of application that has been maintained in the departments.
No, that's what we say. Additional Deputy Commissioner at page 25, while referring the case of the petitioner to the Additional Chief Secretary, referred to an application filed by the petitioner. This letter has not been denied or withdrawn by the respondents, so which means that there was an application way back in 2013. Subsequent application came only in 18. For some reason, it is only that 18 application which was considered. And therefore, the petitioner's name came below the private respondents. Now, unless the government disowns this letter, which they have not, it appears that their uh, her name should have been at serial number 1 in terms of the seniority. So if that is to be reconsidered now, then she has to be given the benefit. Now, if there are no posts available, then if required, your appointment will have to be set aside. If the seniority is to be maintained, and if she is senior, then obviously your appointment was not as per the seniority list. So you tell us what is to be done. Government, all this confusion is arisen because of you. You don't leave it to me, we leave it to the government. You sort it out. You have appointed one person, that person does not know what is the seniority number, who has applied, who has not applied. You have shown her to be at a higher serial number than the petitioner. Now the petitioner's application appears to be from 2013. Okay, heard. Learned counsel for the petitioner, Mr. So-and-so, Mr. Jamil, the counsel for the petitioner, MS so-and-so for the government, and MS so-and-so for the respondent 7. The writ petition is directed, is filed by the petitioner praying for a direction to the respondent department to consider her long-standing claim for being appointed under the compassionate scheme. In terms of the policy for appointment of compassionate, under compassionate appointment, followed by the state of Nagaland. So, the petitioner's husband, late what is the name?
Page 22.
Page 23. The name of the husband is so and so. Page Page 24 is a type copy. Second line you'll find name of the deceased, so and so. Who was working as a what?
DB2,
As DB2, DB Roman 2, under the establishment of the Additional Deputy Commissioner's Office, Futsero, page number 25. Please check the spelling. During his service, he expired on 11th September 2013, leaving behind the petitioner and 6 minor school-going children. Stop. the petitioner's late husband was the sole earner for the family. And after his demise, the petitioner was left in penury with no source of income. Stop. Left with no options, he applied to the competent authority seeking her appointment under the compassionate scheme in a suitable post in the department in which the petitioner's late husband was working at the time of his demise. Stop. The said application was is seen to be the said application was forwarded by the additional deputy commissioner Futsero to the additional chief secretary and commissioner, recommending that the petitioner be appointed under a compassionate scheme. Under the compassionate scheme. Stop. Subsequently, another recommendation was made by the additional deputy commissioner. Sorry. Subsequently, the Futsero and Fek, they are two different districts or
Oh, it's under the commissioner type.
Futsero?
This is something like.
Okay, okay. So you write recommendation by additional deputy commissioner Futsero, Agor paragraph. Stop. It is mentioned here that Futsero is a subdivision under the district of Pek. P-H-E-K, Pek. Stop. The subsequently by communication dated 30 July, is it 30?
Yes.
July 2014. The additional deputy commissioner headquarters, office of the commissioner Nagaland Kohima, informed the deputy commissioner Fek that the commissioner of Nagaland has approved the proposal of the petitioner for appointment of sweeper cum mali on contingency basis in the office of the additional deputy commissioner Futsero. Stop. It was also mentioned that her case be taken up for regularization for compassionate scheme under Group D posts as and when vacancies are available through DLRB. Stop. Thereafter, the petitioner was appointed as a sweeper cum mali in the office of ADC Futsero at a fixed salary of ₹3,000 per month with effect from 5th of August 2014. Stop. The petitioner petitioner is still employed in the same services. Stop. Subsequently, she made another application on 9th of May 2018. Sorry, you see, she made another application in the year 2018 for a grade 4 post. Which was forwarded by the additional deputy commissioner Futsero to the deputy commissioner Fek. Stop. Since no action was taken, The subsequent application dated 9th of August 2021 was also issued to, was also submitted, which also came to be forwarded to the Deputy Commissioner FIC by a forwarding letter from the Office of the Additional Deputy Commissioner Futsero. Subsequently, by communication 6th of June 2022, the Office of the Commissioner, Nagaland Kohima, conveyed the approval of the, oh, this is not for her, page number 35. Okay. However, say, while the petitioner awaited for appropriate orders from the competent department, to her surprise, she found that the respondent number 7 was considered for compassionate appointment, and the approval for her appointment was communicated by a communication dated 6th of June 2022 by the Office of the Commissioner, Nagaland Kohima. So, huh? He, respondent 7 is he, petitioner is she. So, pursuant to the confirmation received, the petitioner, the respondent number 7 was appointed in the said post by order dated 10 June 2022. So, the petitioner being agreed preferred representations before the Commissioner Nagaland as well as the Deputy Commissioner. However, the same remained unattended. However, however, she did not receive any response in respect of the representations preferred. Stop. Thereafter, her counsel issued a legal notice on the Commissioner and Deputy Commissioner, Commissioner Nagaland and the Deputy Commissioner FEC, seeking employment on compassionate ground for the petitioner. Stop. As no reply was forthcoming, the petitioner has approached his court, filing the present writ petition, praying for setting aside the order dated order number so and so, dated 24/5/2022, issued in respect of respondent number 7, together with the appointment order number so and so dated 6th of June 2022, appointing the petitioner on compassionate scheme to the post of multitasking staff. So it is the further prayer of the writ petitioner that the authorities be directed to regularize the service of the petitioner under compassionate scheme against the regular grade 4 and multitasking staff. Sanction post. Stop. Para. Learned counsel for the petitioner has referred to the office memorandum number so and so dated 17th September 2015, which revised the compassionate appointment scheme for the state government employees who die in harness. Stop. It is submitted that in terms of the said scheme, the compassionate appointments are to be considered for group C or D posts. it is submitted by the learned counsel for the petitioner that in terms of the said scheme, petitioner is squarely covered for being considered as there was no surviving member of the family who holds any regular post in the government, in the state government. Stop. It is further submitted that pursuant to the death of her husband, late so-and-so, there was no other earning member in the family to provide for the petitioner and her 6 minor children. Stop. However, without consideration of the prayers made by the petitioner, her case for appointment in Group C or D posts under the compassionate appointment scheme was ignored by the department, and instead she was appointed as a contingency. She was appointed in contingency service as Mali cum Chowkidar, sweeper cum Mali, under the office of the Additional Deputy Commissioner, Futsal, in the district of Fek. Stop. Anything more?
Then we should subscribe to the fiscal model.
Where is that addendum? You have an extra copy? Is further submitted by the learned counsel for the petitioner by placing a copy of the addendum number so and so dated 9th of April 2019 to that the compassionate appointment made under Group C and D posts under the scheme shall be strictly in the order of death, and first preference shall always be given to against those who died earlier and fulfills all the criteria. Stop. Learned counsel for the petitioner submits that this addendum is still in force and is required to be followed by the department, as the same was brought with effect from 9th of April 2019, which is prior to the date of appointment of the private respondent number 7. So, better. The learned counsel for the petitioner on the submissions made has prayed before the court that the writ be issued, directing the respondents to appoint the petitioner in any suitable grade 4 post under the compassionate appointment scheme, and to the best of his information, there are sufficient vacancies available, and the government can consider the case of the petitioner without interfering with the appointments already made to respondent number 7. Fair. Learned government advocate submits that learned government advocate disputes the contentions raised by the counsel for the petitioner. She submits that the government has contested the case by filing an affidavit. It is submitted that the government has followed the have considered the appointment of private respondent number 7 in terms of the seniority of claims, and accordingly his name was placed higher than the present writ petitioner, and he was appointed in the vacancy which arose. So she submits that there is no infirmity in the appointment made to respondent 7. And the case of the petitioner could not be considered as the petitioner had made a claim only in the year 2018, as per the records available in the office. So, where a learned counsel appearing for respondent 7 submits that that your father, yes, his father, late Seli Venu, Selie, then Venuh, who was working as a duck runner under the establishment of the office of DC Tech, Nagaland, died in harness on 4th of July 2017, leaving behind the petitioner, his mother, and 2 younger brothers who had no sources of income and were solely dependent on the income of their late father, of his late father. So, consequently, an application for appointment under the compassionate scheme was made, and the petitioner and the private respondent's claim was duly considered, and he was appointed by the order dated. What is your order of appointment? 3008/2017.
Oh, no. No, no, no.
Appointment 22, I think.
That's 16.
10/6, sorry, 10/6/2022. And since then, he has been working and rendering his services in the post appointed. The learned counsel for the petitioner denies that the petitioner is eligible over the claims made by the respondent number 7. And the petitioner could not establish any ground as to why the appointment made to the petitioner, respondent number 7, should be interfered with and set aside and quashed. Stop. It is submitted that the claims made by the petitioner are not supported by the official records, and therefore her claim has not been substantiated. So the prayer made, the writ petition therefore has no merits, and the same should be dismissed. Learned counsels for the parties have been heard. Pleadings available on record has been carefully perused. So, upon perusal of the writ petition, it is seen that the petitioner's case was recommended by Additional Deputy Commissioner Futsero for consideration for appointment in any grade 4 post on compassionate ground. Stop. This is evident from the communication dated 27th of November 2013, issued by the Additional Deputy Commissioner Futsero to the Additional Chief Secretary and Commissioner Nagaland. Stop. In the said letter, it is mentioned that there is an application in respect of the writ petitioner. In the said letter, forwards, said letter had forwarded the application filed by the writ petitioner. Although the date of the application is not mentioned. Stop. It appears that since the petitioner's husband expired on 11th September 2013 and the forwarding letter is dated 27th of November 2013. The application referred to in the said forwarding letter appears to have been made between 11 September 2013 and 27 November 2013. Stop. What is also noticed is that in the affidavit in opposition filed by the respondent State Department, there is no specific denial about the correctness of the communication number so and so dated 27th 11/2013, passed issued by the additional Deputy Commissioner Futsero. Stop. During the course of the hearing also, learned counsel for the learned government counsel has also not denied the existence of the said communication or the correctness of the said communication. Stop. If although the strict rules of civil procedure are not applied in a writ proceedings, the basic principles of pleadings are required to be adhered to while deciding a LIS. Stop. When there is a specific averment made in the writ petition and the same is not denied or disputed by the respondents in their affidavit in opposition file, then such an averment will have to be accepted to be correct and not denied by the respondent. Stop. Such specific denial is necessary in order to dispute any such specific averments made in a writ petition. In this context, reference may be made to Bharat Singh and others versus so and so, state of so and so. If the communication dated so and so is accepted to be a communication issued by the government, then it is apparent that the not only the death of the petitioner's husband, but her application seeking compassionate appointment also was submitted before the government at an earlier point in time as compared to respondent number 7. Stop. During the course of the hearing and upon the submissions of the counsel for the petitioner that as per his instructions, there are sufficient vacancies available and therefore a direction can be issued by the court to appoint the petitioner without having the need to interfere with the appointment made by the respondent number 7, the learned government advocate was requested to obtain specific instructions with regard to the number of vacancies. So, today when the matter is called up, the learned government advocate has placed before the court a copy of a communication received from the Deputy Commissioner's FEC number so and so dated 3rd of October 2024, where the vacancy position under the establishment of Deputy Commissioner FEC Nagaland is shown to be -- 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. 6. the particulars showing the vacancy position available however, does not reflect that any of the vacancies are marked to be filled up by compassionate appointment. Stop. What is also noticed is that pursuant to the that there is no dispute with regard to the procedure prescribed under the office memorandum number so and so dated 16th of January 2012. There is also no dispute. There is also no, the respondents have also not disputed the amendments brought in through the addendum number so and so dated so and so, whereby it was provided that compassionate appointment made to group C and D posts shall be strictly in order of the date of death, and the first preference shall be given against those who have died earlier and who fulfills all the other criteria. Stop. Since the office memorandum and the addendum are relevant for the purposes of this writ petition, the same are extracted below. Annexure A, page 19, and the addendum. Extract. Next para. A perusal of the office memorandum reflects that appointments on compassionate ground are to be made on a regular basis to direct recruitment posts. And only if regular vacancies meant for that purpose are available in the department where the deceased government employee was serving. Stop. It is also provided that the applicants shall have no claim to appointment under this scheme in any other department other than that where the deceased employee was serving. Stop. Is there any requirement for qualification for handyman? Huh? This is not under MTS. Handyman?
It doesn't come under this also, only that's the stuff. Because it's a difficult job to give it.
Right.
Can you see the road follow the chart?
Yes.
The vacancy post will return to that sheet. For your not water. As the letter pertains to commission.
Oh, this is relating to this matter. Oh,
Where's the vacancy?
so that is 7. There are already 6 vacancies sold.
Yes.
If you take the note,
There are some vacancies.
So that means there are 7 vacancies.
Just because it's not important to government,
All right,
you know, the business services.
all right. Fair enough. As discussed during the course of the hearing, the learned government advocate has placed before the court the vacancy position available under Deputy Commissioner Tech, Nagaland, by way of a communication dated 3rd October 2024. Stop. The chart detail, the chart showing the vacancy position contains a note which states as under. You extract the note. It is clear from a perusal of the vacancy position that over and above the 6 vacancies which are shown, the vacancy was due to the, no, who's Rati Siepa? That's somebody else. In the note,
We got it on 170.
somebody else. So there is some writ petition pending.
It's appended in the, those paper which are submitted earlier. I think it is the change which was brought right.
5 vacancies, where have you shown it? Some document.
Yes, the progress vision also. That's a big loss of the.
But this note does not contain, relate to your husband. He is somebody else. Extraordinarily, you just write that in terms of the note, there is another vacancy available, which however was not forwarded to, as it is stated, that the matter is sub judice before this court. Well, having noticed the documents available in the pleadings and also placed before the court, it is seen that the claim made by the petitioner appears to be at an earlier point in time than the claim made by the private respondent number 7. Stop. The office memorandum read with the addendum clearly lays down the procedure that the compassionate appointments made to group C and D under the scheme shall be strictly in the order of date of death and first preference shall be given against those who dies earlier and fulfills all the eligible criteria. So. Once a policy is framed by the government is expected to adhere to the terms prescribed. And in case of any deviation, there must be plausible or sufficient explanation as to why the procedure prescribed and notified earlier by the government has not been followed. Stop. Under such circumstances, this court is of the considered view that the prayer made in the writ petition has to be allowed to the extent that the case of the petitioner should be considered fairly by the respondent authorities, taking into consideration that her claim was made way back into 2013, and the same is evident from the communication dated so and so issued by the additional Deputy Commissioner Kutsero, and which fact has not been denied by the respondents. Stop. There is no from the vacancy position placed before the court. It appears that there are 6 vacancies available before the court, in the establishment of Deputy Commissioner FEC, Nagaland. And since the petitioner is presently serving as sweeper cum Mali under the establishment of additional Deputy Commissioner Kutsero, who is to consider? Who will consider your appointment? Commissioner. Number 3. The respondent number 3, namely the Commissioner Nagaland, Kohima, and the deputy and respondent number 4, the Deputy Commissioner FEC, will consider the case of the petitioner's claim for compassionate appointment under this office memorandum dated so and so, read with addendum dated so and so, and make necessary and pass necessary orders towards her appointment if she is found to be suitable for the post of multitasking staff in terms of the vacancy produced before this court, vacancy position produced before the court by the learned government advocate. Stop. Considering the vacancies available, this court has refrained from passing any order interfering with the appointment of respondent number 7. Stop. However, if the department, the respondents will consider the claim of the petitioner against the available vacancies shown in the vacancy position in terms of the office memorandum dated so and so, read with the addendum, without any further delay. Stop. The entire exercise be completed within a period of 60 days from the date of receipt of a certified copy of this order. And any such order that is passed, a copy thereof be communicated to the petitioner, served on the petitioner. That petition accordingly allowed and disposed of to the extent indicated above. Yes.
The petitioner is presently of age. She's 43 years now.
There,
Doesn't mean How many data
The-
is already-
While considering the case of the petitioner, for the very, any exemptions that may be applicable in terms of age, the benefit of any exemptions that may be available and applicable to the petitioner should be allowed to be applied while considering the case of the petitioner. The petition accordingly disposed of allowed to the extent indicated. Do you have an extra copy of this? Yes, you can furnish it to the court master because we need to extract it. All right. I hope you don't come back with a contempt case.
I,
For hearing item number 13.
Yeah, please to lodge. Wanted the state council for this case is an engagement item in court two. So we requested you to come up after the listed matter in motion.
We are at the end of the listed matter almost.
He's right now standing in that.
What is this issue about?
Was it just an issue? Because she
Huh? What?
Kohima Town Council had issued some permit for setting up some advertisement posts that we see in the roadside crossing nowadays. Those big, huge, PCA posts and all.
Hmm.
So the petitioner in this case is engaged in business of advertisement. He had sought for some permission to establish such poles around the Kohima Town Council area. Now this town council is established under the statutory only under the Meghalaya Municipal Act section 20 also. Accordingly, he sought for some permission, the permission was granted. He invested his money and he set up this one, and then without giving any opportunity, his permission was cancelled
By whom?
by the same authority.
Where is the cancellation? Page 20.
Page 20 also. Now this order, it can be read just.
Where is the permission granted in the first place?
Permission is at page 15 also.
15.
15 is permission is 18 also. 18.
Yes.
Is it full paragraph? Permission is given when according to Manish communication of petitioner. Some to erect install 5 number minimum measuring 20 to 10 feet along the national highway 29 under Kohima town jurisdiction that is from first grade such and such for a period of 5 years, subject to renewal for every following year under the council conditions in this order will be effective with the and the council and this order will be effective from the issue of this permit. Now the permission is granted on the condition that there are certain conditions are given also. At the bottom, they have written that the Kohima Town Council reserves the right to cancel this permit on breach of the above terms and conditions. And or any other dispute or any other developmental purpose for Kohima Town Council, say object government. Now this permit was issued also. Thereafter, I have paid my license fee also. I have paid for the period of 1 year. Thereafter, also
There was no approval from the other department.
yeah, the orders is the approval. It's not clear what approval is required.
You're free, you're free from that court.
It's
You're appearing in the matter.
lots.
You're free from the other court.
No.
You have to go back.
Lots.
All right, we'll take it up after a while. You come back.
From the supplementary cost list for hearing item number 14.
Was the minor, which is given a certain relaxation period. That is within 1 year, somebody have to attend 18 years.
Oh, it is that,
That will not be applicable in the case for the reason that there is a order of this court. There is a vested right to the petition. To this, to the.
you satisfy us that you have a vested right because this is a compassionate appointment.
Right.
It's not a, it is, prima facie, you can't say it is a vested right. You have a right to be considered,
No.
can't be a vested right.
That particular point of time.
No, this judgment, you're right on the facts of the case, it applies to the minor
Yes.
at the time. What happens when you apply and you
Yes.
become a minor, etc. But the fact remains that the court has returned a finding to say that the memorandum governing prevalent on the date of consideration will prevail. Isn't it correct? That's what the judgment says. So I agree with everything.
No, what
See-
I'm trying to
see-
say is
Huh.
any trust. Independent board.
The judgment, unless otherwise specified, is not to be read as prospective. We are concerned with the judgment, the law laid down by the court, which is binding on the high courts. So the law says it is the office memorandum or rule or circular, whatever, prevalent on the date when your application was considered, that will prevail. Not the one which was prevalent at the time you made the application. In your case, there was an order of the court. Subsequently, you file another case. They came and said, no, we go by seniority. Your number has not come. Then you file another writ petition, is it? Challenging this very order. What did you challenge in the third?
Subsequent order.
Which you ultimately withdrew.
First is 2016. It was not considered.
Right.
It was kept pending the order is kept away at the time. So by this court.
So you came back again before the court.
Well,
Then there was a submission made on behalf of the respondents that it will
it will
be
be considered.
in the order of seniority.
Yes,
Then third time again you came before the court,
yes.
challenging, which was ultimately withdrawn.
Yes.
What was that for?
It's 26. The service the overall the petitioner has approached this court by having.
So you challenged the very same order, isn't it? The order which you, then
There is another court is. Yes, this very same order.
this very same
Yes,
order,
same order, Indian order.
which ultimately withdrew
Yes.
by saying that you will file a contempt petition.
No,
And the contempt which you filed was closed,
no,
but then you accepted their order of the contempt.
the request, you know,
No, that's all right.
we are-
We are not we are not questioning your liberty to assail.
Madam,
We are trying to understand how you want to, how would you like to address the court in the face of the judgments which are presented before the court?
my living task,
Yes,
in the present case, there is a court of this,
right.
as I totally, which, which, hold on, time, but there is no dedicated right in the present case.
No, no. We have understood everything.
Yes.
You tell us how to go around, not go around, you tell us how to deal with the judgments of the apex court.
No, that's why in my reply, there is a rule. It is people with the present,
No, but it doesn't
Okay.
deal with it.
I will be appreciated.
So we don't want you to leave it up to us, because strictly speaking, the ruling which you have relied on in your reply appears to be par inquirium, because it has not dealt with the,
No, the, yes, people.
just referred, yes. It's not dealt with, because it has taken a different view.
Yes.
All right. Yes.
I have issued a review letter of the DIG,
Yes.
bonafide and review letter. Therefore, at the time of considering the application of the petitioner, the scheme of 2002 no longer exists, and the scheme of 2015 was enforced. And as such, in good faith, Your Worship, and in view of the principle laid down in the NCC Doge case, I've considered the case, considered the application of the petitioner in terms of the scheme of 2015. Your Worship. Therefore, Your Worship, there is no benefit intention on my part of.
We made it clear on the last date that he is not pressing he's not pressing against you. That
Yeah.
is made it clear. If there's no, if the petitioner does not press on his claims, where is the question, where is the requirement to decide on this? He's not claiming anything against you.
That's all.
He probably thought, seeing your name, you'll be more conscious about what orders you are required to pass. So therefore, he has arrayed you by party. You don't have any claim against him in person?
Actually, the directive is to the DGB in command.
Then why did you array him as a party? By name?
Maybe he was directed. I'm not missing the order, during the substance I directed.
No. You have arrayed him as a party respondent in private, by name.
By
So, but you are not making any, you are not seeking any relief against him. There is no allegation also against him that it is malafide or anything like that. That's it.
Melody. Yeah, but it's.
No, they have alleged, but there is no relief.
Yeah.
We'll take it. That.
Okay.
What is the respondent number? The respondent 7. Yes.
This is motion to bill for the state respondent. Just like to
verify my submission that when that we considered during consideration of the application was the one of 2015, which was in operation at that point in time, in terms of any trade. And as such, we have to that one, see in some which case.
Okay. Okay. Heard reserve. Yes.
For hearing, item number 17.
Yes. Yes.
The petitioner is the landowner candidate. The land in question is the Mohawk Town Park, which was donated by the petitioner's land. Okay. Now, the fifth fact of the case is that a vacancy house in the one store of the park, okay, and the uncle of the petitioner. He,
Applied.
not the uncle, but his brother-in-law, who is not a landowner. Uncle applied on his.
Brother-in-law is not a part of the clan.
No, he is not. The uncle is a part of the clan, but the uncle submitted an application for his brother-in-law on the basis of.
No, whose brother-in-law?
The uncle's brother-in-law.
Uncle's brother-in-law.
Yes. And he was appointed. Now the petitioner submitted representation for.
He must have done it under the instructions of your aunt.
Right. That is the crux of the case. Now my case is that it is, since appointment is covered by a notification, then it's 5th March 2018.
Where is that?
It's at page 19, page 19, and it's a C.
Yes. When was the land donated?
Land was donated in the 1960s, originally it was donated to the.
When was the appointment made?
Appointment was made in 2019. At that point of time, the petitioner was. He's a daily wage earner, so he was staying in his mother's village. Changi. Then subsequently, he came to know that the present respondent has been appointed on the basis of landowner. Obviously, state respondents are now denying that because of appointment was made on land ownership basis, but the letter itself is very clear. The letter of the uncle is also very clear. But if at all, the petitioner is, if at all, landowner candidate may not be considered. on the basis of the representation and notification. It has to be, the boss has to be advertised. No advertisement was made on the recommendation of the answer of the petitioner, the private respondent has been appointed. That is the.
Yes, who's for the council? Municipal? What do you say?
Their ownership. One of the committee members is in the appointment. On 2014, after a coalition meeting of Municipal Council, they orders the Malaysian Village Council. For the district, not be appointed.
No, no. You mean to say, other than the private respondent, somebody else is appointed?
Okay.
Who is the landowner? Petitioner's claim is that he belongs to the landowner's family. But instead, respondent 5 has been appointed.
Yes, lordship
He submits that he is appointed as a landowner, or given the benefit of a landowner family. Whereas it is the petitioner who claims that his clan has donated the land, etc. Now you want to say from the petitioner's clan, somebody else has been appointed?
lordship. Or on the vacancy caused by one Shamal Guru, who is also a non-land owner. So for that case, the petitioner, the respondent government was also appointed. Not on the basis of the ownership, but on the basis of only the applicant who is capable for a post.
No, but there has to be a selection. How have you undertaken the selection? How do you know he is capable for the post? What is the process you have adopted? You can't decide something on a public post that X is capable, Y is not capable. There must be a procedure prescribed. What is that procedure?
There was no applicant, only the respondent.
But maybe, but you are required to, municipal council is a public office. You cannot appoint anybody on the basis that somebody applied. There has to be a process. Who's appearing for respondent 5?
I'm getting for respondent 5. The better option. I'd like to raise the limiting objection as to the maintainability of this petition. And also, let's see that one point of there is suppression of nefarious acts. Number is the delay coming to number 1. As regards to the suppression. The spirit of the body. This ordinance to be given to landlord, not in perpetuity. Once this quota has been exhausted, the landlord no more deserves the right to be appointed. And in this case, the fact that a family member of the petition had already been appointed at some prior point of time, therefore, the petitioner is not exposed this and in my in the future, my role in my academics, my response, I virtual. I because that's the one for answering to the ever making raises renewed objection with regard to the maintainability of the resolution. The petitioner has suppressed the material fact regarding grade 4 appointment already availed by one of their family members on an ownership basis through a decision of the coordination meeting between both the municipal council, the Village Council, and the landowners on 12/6/2024. Hence, the petitioner is claimed fought with the court and before this court without a clean hand, and as such, the present petition is liable to be dismissed without entering into the marriage. Also, in this, you are,
Who is the person appointed? Who,
Lordship,
where are the particulars?
page 11. Lordship. At page 11. It
Yes.
should be. Lordship, at page 10, this the agreement arrived at between the municipal council and the landowner. Chair. The agreement was arrived at where an appointment will be given to the landowner, and accordingly, in the following page, an appointment, a grateful appointment was granted to his daughter. That's my lord, going to be the operating part of this agreement. This is
All right, not necessary, all right.
so, coming back to my first.
How do you,
position on the-
how do you establish that this lady is a relative of the petitioner? From where do you establish that?
I may be permitted to read, page 10. There are three,
All right,
the, my also.
yes,
Yes, the BCC and members of the Mochung Village Council intervened and suggested to appoint one member of New Shimayang's family as grade 4 post on scale B by MMC, and New Shimayang should stop site leveling activities in the park area to maintain as it was before in the interest of public service.
Hmm.
So according to this appointment order in the following page, in the interest of public service, Ms. Kina Lena, daughter of Mr. Munshimayam of Mokuchung Village, is hereby appointed as office beyond on actual basis on the scale of pay of rupees so and such to effect on 1st July 2014 plus 100 months. If my lord may grant permission without, before I get into the merit, if my lord may kindly hear me on the laws that the project. So I have made a specific development in case. Right, they did that. There is a question of the, and the additional is not.
No,
I
no.
will in reply to something that
First, we'd like to understand the connection between the person appointed and the petitioner. How do you establish the connection?
they are in the plan.
Same clan.
Yes.
Now, tell me, how is the land holding? What is the law or what is the manner of land holding in Nagaland? Is it held by private individuals? Is it held by clans? How is it held by?
Private lands are there and then clan lands there. So in this instance, it is clan.
So if it is, how many, say, approximately, what would be the size of your clan, number of persons?
So number of members, I cannot specifically.
Approximately?
More than 30-40 members.
More than 30-40
Yes.
members.
With the people.
So these 30-40 members are considered to be the owner of a particular
Yes.
area of land.
Yes.
Now, hypothetically, let us say you have 100 acres of land
Yes.
belonging to these 30-40
Yes.
members, belonging to the clan comprising of 30-40 members. Out of that, 10 acres are donated to somebody. Now, out of these 30-40, who stakes a claim?
All of them have equal right.
So who decides? Because there can be, there has to be only one post.
The system in among the hours, since I'm from the hours, is that the one who is the eldest in the clan, he has the biggest say. For instance, we have two cultivations, so during two cultivation periods, the eldest will get a branch share, he will select. The one with two people and it goes on downwards. Then when it comes to decision on clan land, it is to be the village, then if you want to do something on the clan land, you have to get permission from the elders. Without permission from the eldest person, you cannot.
So-
You are one of the members. you
So,
cannot come to
so
the council.
if you want to claim
Yes.
a particular job, there must be sanction from the village elders,
Yes, from the clan itself.
clan
The
itself.
you-
So is there a decision of the clan members, elders, that you are entitled to this post?
Yes, I have.
Have you made the village council a party?
No, the village council is only, the commentator, they only attest to the claim of the particular person.
That's right, but how do we know in whose favor the claim was made?
Your Lordship, page 14, this is the landowners who have issued the certificate, the petitioner's plan. And it's
But-
A1.
No, but it does not reflect that this is by the village council.
And then the second one, this is the page, annexure A2 is the village council. They have issued the certificate certifying that the land in question belongs to the issue plan and the petitioner is the. Well, I think that
Which village is
This
this?
is Bohoksong village,
Mukuksung
Yes.
village.
the name of the which the present Bohoksong town has been. named.
And what is the purpose of the land which you have donated? What is it used for?
For park,
What is is there a name of the park?
it's called Bohoksong Town Park.
Okay.
Town Park, Bohoksong is called.
Then what do you say with regard to the materials placed by the private respondent?
Your Lordship, this is the same person, the uncle of the petitioner. He has been. The agreement was made between the uncle of the petitioner along and the town council. The petitioner had no idea about it.
No, there is a signature of the council chairman.
Yes, the village council chairman is also there, but prior to this 2018 notification, okay? Prior to this 2018 notification, the established, the practice was that whenever vacancies arise, if the landowners claim, they would be given preference. That was the position. Now, in this case, what happened was the vacancy arose. It ought to have been, if it does not come within the, because the 2018 notification, clearly says that if there's an agreement. And if it is a oral agreement between the landowners and the,
Now,
State?
in the face of the materials placed, contradictory materials placed,
yes.
how do you propose the court will proceed in the matter where there are disputed
Lordship,
questions of
Yes,
fact?
my prayer, I have taken two grounds in this petition. As per the report from the application submitted by the petitioners under in favor of his brother-in-law, it is obvious that he is claiming appointment of his brother-in-law on land ownership basis. Subsequently, he was appointed.
No, that is one
That
aspect,
is one aspect.
one
So
aspect.
because of that, I am saying that I am a landowner. I have a right to be considered a head of this person who is a non-landowner. That is my first ground.
Right.
Second ground is, if at all, the vacancy does not fall within the procedure of the notification, that is for appointment of landowners, then in that case, the post ought to be advertised. Now that it is up to the district administration to determine whether I am eligible to be considered as a landowner candidate or not. After due consideration, if it is found that I am not, the vacancy.
There is no
cannot be, then
There
in
is
that
no,
case,
there is no scope for consideration
even in that case. yes,
because the post is already filled up. So there has to be materials enough for this court, placed before the
Yes.
court, to issue a direction to the respondents that yes, prima facie, it appears the petitioner is the lineage of the landowners.
Yes,
Therefore, his claim has to be considered.
yes.
Unless you have strong material before us.
They are not denying that I'm not a landowner. What they are saying is that another landowner has been
Already been given, yes,
Already appointed earlier.
Earlier.
At earlier point of time.
right.
So now, this vacancy, which has now been filled by a private respondent, it cannot be claimed by a landowner. That is what they are claiming. That is their claim. So the question of land ownership, the issue of land ownership, so far as that is concerned, the state, the state respondent or the private respondent, they are saying, I am not a landowner. So that aspect of the matter is over your lordship. But so far as the present post is concerned, it is for the district administration after the notification, formal notification for appointment of land ownership, and then please honorable court coordinate with office honorable court and go to the direction. Even in cases where someone from the clan actually involved, because there are different families involved. In those cases, the district administration will determine as to whether this should go to the present applicant or not, by the district administration. Then only after that, if it is not, then after that, it may be advertised.
Wait,
Yes.
private respondent, tell us one thing. The land, you are appointed on the basis of land ownership.
The records speak for itself.
Hmm.
The appointment order, it's not like in the page, my appointment is. Even prior to me, one, Sanchit Guru was appointed, what also not then, and the petitioner brings no human right at that point of time.
What is the stand of the government in respect of the appointment? That he was a landowner. On what basis you have appointed him? Suitable.
He's the only.
That can't be the ground for appointment anybody in a public post. You'll have to advertise it. It's a sanctioned post, isn't it? It's a sanctioned post.
There has been so much delay, petitioner has been speaking over his rights.
Maybe, but if it is, when were you appointed?
But I was appointed in 2019.
19, and the petitioner, this writ petition is filed in 23.
Lord. Then. I'll be, well, he's not open to accept that.
No, but if you're,
Right is effective, also, the petitioner.
no, but the fact is that if your appointment is illegal, it is illegal. Irrespective of somebody raising it or not raising it, you are in a government post where assuming the petitioner is not eligible, somebody else may be not aware that this post is available, they could have applied for. Unless you say that no, it is by way of proper selection, advertisement, etc., I have been selected. If it is not there, then the council is to answer as to why it has not been done.
Such cases, delay can be fatal, and even coming back to the.
No, delay may be fatal with regard to the claims of the petitioner that he should be considered as a landowner, this, that, it's a different issue. But if prima facie we find that your process for entry is not there, what stops us from issuing a direction to the government to?
Because the petitioner very well knew that the quota for land ownership of others will be available. Since the petitioner approves the property clean hands project, the law is well settled that in such cases, the case to be dismissed at the.
Yes.
And that the relief cannot be entered into the.
He has two prayers, he has dual prayers. Yes, government, we are waiting for your response.
Yes, Lord.
You come back in the second half, we'll take it up. You get your instructions, whatever you want. How many It's two matters more. Right? We'll take it up in the second half.
Your lordship, immediately after the second half, that one review petition. Which was.
Oh,
That is to be taken up.
all right. Then you give a date. We'll go.
One day,
Don't know. Monday, there's a DB plus.
Tuesday.
DB plus.
Monday, how many matters are there?
Monday, besides DB 10 matters.
10 matters. All right, we'll have it on Monday.
Your lordship.
You come back with your instructions, whatever you have. So what is the process by which it has been selected? And yes, we'll take it up in the second half.
Possible version na. Possible version. Low level. Cuidado. Era para ver. For hearing item number 13,
Yes. Even if it takes the whole day, I have no problem. Yes.
I have to go again.
No, you want to go back, say that. You want to go back by that 4 o'clock.
Which way we take? I'm going to walk over council.
Or you're going by road? No, I thought you were trying to take the Shatabdi at 4 o'clock. Yes.
So Lordship, the petitioner here is engaged in the business of.
I recall whatever you said in the previous half. Now the question is, it says that there is some.
Cancel people lack of approval from concerned department.
Right,
Now, Lordship, if I may take you Lordship to the Nagaland Municipal Act.
Hmm.
The act under which this permit has been granted.
right.
Now, Lordship, first of all, before that, Lordship, we have to see this permission was granted and thereafter cancelled by the AGC and Administrator Chumukidima Council.
Hmm.
Town Council.
Hmm.
Now, Administrator has been defined in section 82 and 83 of the Nagaland Municipal Act also. 2001.
Hmm.
In 83, because there is no elected body at the was present at the period of time, so administrator was handling the operation of the statutory body, and as per section 83, Lordship, all powers and duties of a municipality.
Hmm.
Also comes to 83 2.
Page number?
Is number 280 of the same one.
No, what is the section?
Section 83,
83.
clause 2.
Yes.
One says, notwithstanding anything contained in this act, where due to certain special emergent or unforeseen circumstances, election to a municipality cannot be held or completed before expiry of its duration specified in section 10 or before expiry of a period of 6 months of its dissolution, the government may by notification appoint a government officer to be known as administrator to exercise, perform and discharge the powers, duties, functions of a municipality subject to such direction as may be given in this behalf by the government.
Hmm.
Now, to come to 2 also, all powers and duties of a municipality, chairperson or deputy chairperson, when the election to constitute a municipal council or a town council as the case may be, cannot be held or completed, and the committees thereof shall subject to such direction as the government may provide to give the initiative to be exercised and performed by such administration. That is, the administrator will perform on behalf of all the things. He has the power to act on behalf of all the municipal.
Hmm.
Now, what's
Yes.
section 20 defines the town council also. What is a town council?
Hmm.
And Lordship, now if we come to Lordship, chapter 5, section 161. This part of the act
Hmm.
relates to advertisement also. The tax on advertisement other than advertisement newspaper.
Hmm.
But here also, there is a section 161, 162.
No, show us from under what provision these permits, etc. are issued, how it is to be issued.
162 also.
160,
Section 160.
yes. Yes,
License for use of site for purpose of advertisement.
Hmm.
Clause 1. No person being the owner, leasee, sub-leasee, occupier, or an advertising agent shall except and in conformity with the terms and conditions of a license, use or allowed to be used any site in any building, land, building, wall, or erect, or to allow to be used any site in any land, building, wall. Just getting this one. To be erected in this site. Hoarding, frame, post, kiosk, structure, neon sign. My thing comes under structure also. This is the individual structure. Neon sign or sky sign for purpose of display of any advertisement.
Hmm.
Now, if you come to clause sheet also, the chief officer shall make an inspection as may be necessary and within 30 days from receipt of an application. Grant or refuse or renew a license as the case may be on payment of such fees as may be determined by the municipality by regulations. Now, under this 162.3, I was granted license also after due inspection and the site clearance was given by the town council also.
Hmm.
Because it also comes to my application at page number 15 of the application. I had asked for.
When was it granted?
It was granted on what's it? What is it? 4th November 2022.
22.
2022. It was granted on 4th November. My application is on. I had filed for the application on 7/10/2022. In the application, I had specifically sought that at least 10 years lease may be given to me because such kind of things require certain amount of investment and the return of investments requires some time. So at least 10 years may be given. But as per regulation, this one was allowed for 5 years period also. Subject to renewal every year.
Hmm.
Now, accordingly, after permission was granted, I submitted the fees which the stipulated fees of rupees 1 lakh and submitted before the Supernumerary Town Council on 12/11, and I started the work of erecting those things. I had invested around rupees 20 lakhs for investing those, setting up those 5 poles also. Now that also those were ready. Suddenly, this order was passed on 19 December 2022, saying that cancellation of permit. And it says that the same permit is cancelled due to lack of approval from the concerned department. Now, my lord, the department which gives the permit is the municipal department. Now, there is nothing in this order to show where or how or which other department requires has cancelled the approval or what is the reason for the and no we were not given any notice before issuing this cancellation of permit. At least hear us that if we have defaulted in any way, if I have defaulted in any way, I may rectify it. Nothing was given and then they have issued their order. That's why I have challenged this repeat order also. Gross violation of nature and justice also. Now, status filed its affidavit proposition also. Even the affidavit proposition doesn't contain any reason. They cannot, but even then also doesn't contain any reason for what reasons this order has been, this permit has been cancelled.
Yes.
When it also comes to paragraph 7 of the affidavit proposition, it just states that with regard to statement 7 in the deponent reiterates the statements made in preceding paragraph. However, at the cost of repetition, the deponent states that there was a gross violation by the petitioner, so granted.
permits holder, so granted, and moreover, petitioner permit allocator was cancelled due to lack of approval concern during compliance. So at least I am entitled to know also
Hmm.
which department, what has done, what is my mistake, what violation, gross violation I have done.
Right.
So also, on this ground also, I am including this order also, that it's going to be set aside, I'm just praying to it. I have certain documents also.
Yes, give us.
I'll give the citation.
No, no, but why don't you place it? What is the, if you have brought judgments, place it.
And one more thing also before I place the judgments. Again, after issuing the cancellation order, they have now asked for the payment of fees of the next year. They have reviewed my case.
Hmm?
After issuing the cancellation order, they have again now asked for renewal fees from me and I have paid the same. They have again collected the renewal fee for the year 2023 to 24.
Why have you paid? The order is, permit is cancelled. Anyway, give us the judgments. Which one?
Canara Bank.
Cite the
Yes,
judgment
no,
if you
sir,
want to cite it. You don't,
2023,
Yeah.
2003,
1 minute,
4 SCC,
1 minute. You have copies? You have the books? 1 minute, just one. Let me see if it comes out here, then you come. Yes, what are the citations?
2003, 4 SCC also.
2003, 4,
4 SCC.
page,
557, 557.
okay. Yes,
Paragraph 19 also.
yes.
Now, before coming to this journal, also, I just want to show one more thing from the animals. If lordships comes to section 160. Section 160.
168,
Yes, 168.
yes.
Looks good.
Hmm.
Power of chief officer in case of a contravention. They
Yes,
are alleging that there is a gross violation.
yes.
May I read also?
Yes. please.
If any advertisement is erected, exhibited, or fixed or retained in contravention of any provision of this act or any regulation made here thereunder, the chief officer of the municipality, in this case the administrator, not saying, by notice require the owner of the occupier of the land, building, wall loading frame, post kiosk or structure upon over which the same is erected, exhibited, fixed or retained to take down or remove such advertisement within 48 hours of service of notice, failing which he may enter the land, building property and cause the advertisement which will be taken or removed. Now, here it speaks of notice also.
Hmm.
Even that was not done in our case. A notice is given that this is the thing, this is contravened for these reasons.
Yes. Then you refer to section 83, 168 and any other section?
So we also section 20 for defining what is town council, that it comes to be a town council comes under this act.
Okay. Yes.
Section 20, section
And
82,
where is the license under?
and the 162 also.
162.
160. More specifically, 163 also.
Yes,
And then also 168.
yes, 168. Then, para 19.
Paragraph concept. Concept of natural justice has undergone a great deal of change in recent years. Rules of natural justice are not rules embodied always expressly in a statute or in the rules framed thereunder. They may be implied from the nature of duty to be performed under a statute. What particular rule of natural justice should be implied and what is its context should be being given in a given case must depend to a great extent on the facts and circumstances of that case, the framework of the statute under which the inquiry is held. The core distinction between the judicial act and the administrative act has withered away. Even an administrative order which involves civil consequence must be consistent with the rules of natural justice.
Okay.
The expression civil consequence encompasses infraction of not merely property or personal life, but of civil liberties, material deprivation, and non-pecuniary damages also. In its wide umbrella, everything that affects a citizen. In its wide umbrella comes everything that affects a citizen in his civil life. This is one paragraph I'm referring to. And what's it? 2001.
Yes.
2001 one SCC.
2001, 1 SCC.
Yes.
Page,
182.
paragraph.
Paragraph first and second paragraph. Procedural.
Paragraphs and 1 SCC.
2001 one SCC 182.
Yes.
Now, check paragraph 1, it's just variation. Check.
Yes.
Since the decision of this court in Kraipak case, AK Kraipak versus Union of India, one golden rule that stands firmly established in its that the doctrine of natural justice is not only to secure justice, but to prevent miscarriage of justice. What, however, does this doctrine exactly mean? Lord read about 40 years ago in Reach versus Baldwin very succinctly described it as not being capable of exact definition, but what a reasonable man would regard as a fair procedure in a particular circumstance. Who then is a reasonable man? The man on the Chaplam omnibus. In India, however, a reasonable man cannot but be a common man similarly placed. The effort of the Lord Reed in Reach versus Baldwin is not attributing a definite meaning to the doctrine, but attributing it to representing a fair procedure still holds good even in the millennium year. As a matter of fact, this court in the case of Mills Co. Limited versus Union of India upon the reliance on the attributes of the doctrine as the above stated as below. The second question, however, as to what are the principles of natural justice that should regulate an administrative act or order is a much more difficult one to answer. We do not think it either feasible or even desirable to lay down any fixed or rigorous yardstick in this manner. The concept of natural justice cannot be put in a straitjacket. It is futile, therefore, to look for a definition or standards of natural justice from various decisions and then try to apply them in the facts of any given case. The only essential point that has to be kept in mind in all cases is that the person concerned should have a reasonable opportunity of presenting his case, and that the administrative authority concerned should act fairly, impartially, and reasonably. Where the administrative officers are concerned, the duty is not so much as to act judicially as to, the duty is not so much to act judicially as to act fairly. See, for instance, the observation of Lordship, this, we must skip this part. Lordship will take us to.
Yes.
While it is true that over the years there has been a steady refinement as regards this particular doctrine, but no attempt has been made, and if we may say so, cannot be made to define the doctrine in a specific manner or method. Straitjacket formula cannot be made applicable, but compliance with the doctrine is solely dependent upon the facts and circumstances of each case. The totality of the situation ought to be taken note of, and if on examination of such totality, it comes to light that the executive action suffers from bias or non-compliance with the doctrine. The law courts in the event ought to set right the wrong inflicted upon the person concerned, and so would be a plain exercise of judicial.
Okay. Yes, respondent. Any more? Anything?
There.
Huh?
There are some, it's okay, also.
On the same point,
Same point.
natural justice.
Natural.
Why are you bringing so many judgments on natural justice?
Also, I guess what I got.
Yes. Yes. Yes.
The state is filed with counter.
Hmm.
Where the paragraph. Citing the good in the report, the final answer, the following the thing, the final. Stating more particularly stating in paragraph 7.
You're referring to the one filed by the additional DC.
No,
Yes.
if I remember.
Yes.
More particularly paragraph 7.
Yes.
That with regard to the statement made in paragraph 7, 8, and 9. The statement made. However, for the course of the petition, the opponent said that there was a gross violation by the petitioner, permit order so granted, and moreover, the petitioner permit government was cancelled to the type of control from the city department did not address. It is written that till there no permission was issued to any other, therefore no illegibilities or infirmity has been committed by the department in cancelling the permit of the petitioner. What would my guidance come to the petition filed by the petitioner into page 18.
Hmm.
Page 18 and it's 30. And it's 30 of the difference.
Yes.
Logic. The permit was issued on 4 November 2022.
Right.
Logic, if I'm allowed to read the order of the permit.
Yes. Yes.
Permission is hereby accorded to Municipal litigation Gauhati, Assam to install 5 modes of uniform measuring 2010 along the National Highway 29 under Kohima County jurisdiction. I from first gate to yes working plan for a period of 5 years, subject to the renewal of ever of every following years under the following terms and conditions, and this order will be effective from the issue of this permit.
Hmm.
The permission is granted on the condition that I will only with the referendum of two
Yes,
conditions. The permit holder shall abide by the rules and regulations of the Municipal Town Council, which will come into force from time to time.
Hmm.
And the last line, last paragraph. The Kohima Town Council CPC reserves the right to cancel this permit on breach of above terms and condition or any other dispute or any other departmental purpose of the Kohima Town Council / government. So, Lordship, here additional is relying on Municipal Act Section 168 by 123, Lordship. However, Lordship, the permit that was issued by an ADC, Town Administrator Lordship. Here, the permit itself is very clear, Lordship, and it is crystal clear that the Kohima Town Council reserved the right to cancel this permit. So even if without issuing notice, Lordship, if at all there is a breach and there is a breach in terms and conditions, Lordship, or if there is any dispute as such, that the Kohima Town Council has a right to cancel the permit. Therefore, Lordship, basing on this Lordship, page 20 is the cancellation of the permit. And next year follow. Here also it's clearly mentioned that cancellation of Pata with reference to the permit issued to the managed communications so and so on 4th November 2022 regarding permit to carry install 5 nodes of uniform measuring so and so at Kohima Town jurisdiction. The said permit is cancelled due to the lack of approval from the concerned department. Lordship, this stretch of law and it belongs to the National Highway. So approval, no, whatsoever has to come from the National Highway.
Well, where have you stated all that? Even in your affidavit, you have not stated all that.
Lordship, we are family.
Why? Then, why should we take your submission
Lordship,
without any supporting contention or papers that it belongs to National Highway, therefore permission was required to be taken?
Lordship, since that is the only instruction that I see, Lordship, that's it.
That,
Stretch of law belongs to the National Highway.
no, but that
So,
has to be, you bring it on record. If you want. It's a submission you are making without any supporting documents. So you get some documents, something to support your contention that this is, belongs to National Highway and permission is required to be taken. Otherwise, it's a clear case of cancellation at the whims and fancies of the authority concerned.
Lordship, I think there is a reason, Lordship. I have saw the instruction, Lordship, but this is the only instruction that I have.
But
So based on that instruction.
only oral instructions.
No.
Yes.
Let's suppose Lordship, I have been doing this business for a long time, Lordship. In fact, this road starts from Limapur and comes to Chulpi. And also goes to now. I have installed similar in Kohima also. Lordship goes down to Lordship, see entire road stretch of Kohima. Here it's installed under the permission of Kohima Municipal Corporation. It's the same thing, Lordship. There's nothing about National Highway here. The same road configuration I have installed here also.
Yes, that's all.
Lordship, since further instruction, I have done that.
No, but your instructions, whatever you submitted now,
So while seeing the permit, it has been clearly stated that page 20 and it's here for. The same permit is cancelled because of the lack of approval from.
no, so where are the documents to show that it was put up for approval, approval was rejected, nothing is there. You bring it on record if you have. You get the file, let us see the file, at least you can get the file. You should have produced the file that it was produced, but approval was not granted.
But on many occasions also. Not for. For the instruction. This is the only instruction that I have. For. Being that would be a total exercise which. On many occasions I saw for instruction. So I think,
No, you call the concerned officer, let us have him here. Who is the authority here? Deputy Commissioner.
Lordship, addition, ABC come administrator.
So you call him here, we'll call him in Chumukadima town. Let him be present in court on Tuesday.
Or not, lordship, I mean, it means sometimes we get a.
You get it on Tuesday.
Lordship.
You get it on Tuesday. No, see, Tuesday, don't tell me that you need further time. Therefore, we want the whole records to be here. We want the officer to be present in court along with the records. Call for the records.
No.
Will you be able to produce the records?
Lordship.
Mr. Kapil, you see, he's making certain submissions, but these are not supported by the governments.
Not by the order also, not by.
Or it may not be there in the order, it could be there in the file. So we would like to have a look into the file, find out what is the status here, if anything is available. Otherwise, we can't, I mean, whatever he has submitted, but unfortunately not supported by any information. So, and he is candid enough to say that instruction sought for has not been furnished.
Lordship.
So we'll put that in the order and ask for the records, connected records to be
Lordship.
delivered to you for examination of the court,
Lordship.
right?
Lordship.
If you. No, sir, this is 1 minute.
Hmm.
There is one, somewhere I found this. What is this jurisdiction of this?
No, no. You are challenging this on the ground of natural justice, number one. Number two, you are further saying that violation of some, the non-approval by the department.
Yes, sir.
So there is nothing to show that this was required to be approved. It was sent for approval. It was rejected, whatever was there. So under the circumstances, either we have to call for the records to find out what is there. How else do you pass an order here?
Yes, lots of it. What was, I was trying to say is lots of it. This may not be even legal. I can show what this. See, this also erected in the area which is under the jurisdiction of town council and not highway much. Because.
No. Highway or no highway is a different issue. That will come only when we find from the records that yes, it was sent to the concerned authority.
No,
But the formal convenience on Thursday, because.
No, we keep it on,
That has to come from. Yes, the doc.
you go on Monday, you send somebody on Monday, you ask them to come back on Tuesday. Huh? Or we keep it on Wednesday after DB, after division bench, right? I heard Mr. DJ Kapil, learned counsel with the petitioner, Mr. V. Zimomi, learned government advocate appearing for the state. The petitioner is before the court challenging the cancellation order. Cancellation order dated 19 December 2022, by which his permit, the permit earlier granted by the ADC cum administrator Chumukudima Town Council was cancelled on the ground that it lacked due to lack of approval from the concerned department. Stop. Para learned counsel for the petitioner submits that petitioner was granted the permit by order dated 4th of November 2022. And this was a conditional permit whereby as many as 5 conditions were mentioned. To the effect that if any of these conditions were violated, the permit can be cancelled. Stop. It is submitted that pursuant to the grant of the permit dated 4th of November 2022, petitioner invested in erection of the advertisement, erection of the poles. Have you started erecting? No.
It's already erected.
Okay. So he's invested money to execute the work entrusted to him by way of the permit dated so and so. However, without any prior notice, the impugned order dated 19 December 2022 was passed and his permit was cancelled. Stop. Petitioner submits that this particular this cancellation is violative of the basic principles of natural justice, and no notice was given to the petitioner, nor any reasons were furnished as to how the petitioner's permit was cancelled, notwithstanding that there was no violation to any of the conditions mentioned in the permit dated 4th of November 2022 by the petitioner. Stop. Para. During the course of the hearing, the learned government advocate submitted before the court that the permit was cancelled due to lack of approval from the concerned authorities, as is reflected in the permit itself. Stop. The concerned authority is the National Highway Authority. As the permits, as the advertising hoardings, is it?
Advertising pole.
Advertising poles were required to be erected along the NH highway, NH 29. NH 29 in around the Chumukudima town. Stop. Such approval having not been granted by the competent authority, the permit which was earlier granted was cancelled. Stop. However, such contentions raised before the court are not supported by the averments, notwithstanding the affidavit having been filed on behalf of the respondents. Stop. There are under such circumstances, this court deems it proper to call for the relevant records for perusal of the court, for perusal by the court. Stop. Let the records, complete records connected to issuance of the permit dated 4th November 2022. Issuance of the permit by the order number so and so, page number 18, dated 4th November 2022, and the subsequent cancellation by order number so and so, ID order number so and so, dated 19 December 2022, be placed before the court by the government advocate. Stop. Further orders in the matter will be passed upon perusal of the records as directed to be called for. Counsel for the petitioner is permitted to appear before the court through BC, if so advised. Not that we don't want you to come to Gauhati, I mean to Kohima.
I love to come to also, but
It's a wonderful time to come to Kohima. But in case you are unable to, VC is available.
beautiful also.
Beautiful.
Please help me.
Yes. So you go back and come back on Wednesday. This matter again on Wednesday. Okay.
And Madhu. Right. So लिख लीजिए तनय से। I will find this.